Hi, my name is Paul Buglers. I'm the senior family law lawyer with SBMB Law. A parenting plan is a written agreement between the parents of a child or children. The parents may either have been married in a common law relationship or perhaps didn't cohabit at all, but they're now separated and they have to have a written agreement detailing their rights and obligations going forward with respect to raising the child. Generally speaking, a parenting plan is normally contained in a comprehensive separation agreement, which might deal with other issues such as division of property, spousal support, etc. But it can also be a standalone agreement in which the only discussion is with respect to the children. The first determination in any parenting plan is whether or not the parents will continue to have joint custody of the child. Custody pertains to the parents' legal authority over the child in terms of dealing with teachers, doctors, and with moral training or religious upbringing. As the parents of the child, presumptively the parents have joint custody. The question is whether that should continue now that they're separated. So that agreement has to be reached or determined. If it's a sole custody situation, one parent will have the final say on those important questions. In addition to the custodial arrangement, the parents will also agree upon the parenting plan detailing the specifics of access. There are traditional scenarios where the child will primarily reside with one parent. There would be the potential for a shared parenting situation where the child resides with each parent equally or something close to equally, and that can either be on an alternating weekly basis or some other arrangement. There can also be situations where, if in cases of more than one child, there would be a split parenting arrangement where one child primarily resides with one parent and the other resides with the other parent. The parenting plan, once the time that the children spend with each parent has been agreed upon or determined, what will flow from that is also the consequences that flow financially with respect to child support. If the children primarily reside with one parent, that parent is presumptively entitled to table child support under the child support guidelines. In a shared parenting arrangement, there may still be child support obligations, but those would have to be determined based upon a more thorough analysis of the overall economic situation of the family. In addition to the basic table child support, the parties would also normally agree upon the sharing of special or extraordinary expenses. That sharing is normally done in a proportionate to income basis, which is the requirement under the federal child support guidelines. Though the parenting plan, once finalized and to be enforceable, it has to be in writing, signed, witnessed, and dated. Though it is a contract between the parents, it is technically not binding on the courts. So though the courts will presumptively want to honor or respect the wishes of the parents, if there is a change or a need to review the agreement, the court is not bound by that contract, and the court has the power to impose a resolution or a determination which is in the children's best interests, which may be on terms that are different from the terms that the parents agreed to. The other aspect of parenting plans is that children, of course, get older and their needs change. So the parenting plan will likely have to be reviewed at some point in the future. Many parenting plans will have a dispute resolution clause incorporated into the agreement, which sets out a mechanism for the parties to deal with those potential changes as the children get older. Children, of course, once they get to be 12, 13, 14 years of age or older, also begin to have an impact themselves on the outcome of the parenting plan as their wishes become more mature and more determinative. Should you have any more questions, please feel free to consult our website or to contact us.